Hey guys, it's Kathy with a K because everybody keeps asking, even though I keep saying Kathy with a K. I hope you guys are doing well. It's my first day of the weekend for me, so I'm doing great. Well, it hasn't ended yet. It started yesterday. Oh my. Okay. Um, I got some new judges again today, and the worst coworker ever. You guys probably have a lot of stories about your worst coworker that you ever worked with, but trust me, it's not her. She's terrible. The worst wedding ever is coming up, um, and new judges. So I feel like I sort of painted myself into a little corner on this channel because I don't do Manning, I don't do Simpson, I don't do Webster. I love them all. I miss them because I don't have time for them anymore. But I have new judges, so we I don't have like the comfort of, you're gonna log in a Law Talk with Mike and you're gonna see Judge Simpson do his thing and it's great, and you're gonna see it, so you have your favorites. They're almost like superstars, TV show stars. Um, I don't have any of those because mine are all new. But I think if we just keep going, we'll just eventually find the good ones together. So I'm just going to keep going and see if we can't find our own playlists of good judges in Colorado and Indiana. If I could just pick a state, that might that might make it easier. But maybe I've never been diagnosed with ADHD, but I can't just pick a state. I have to keep looking for new, new, new. I want to start off though. Last stream, I think it was Cloud Illusions. She, and I'm assuming it's a she. If it's not, I apologize. But she said that the courtroom was, had the real nice white wood in it. And it makes a difference. I'm telling you. I have a court. I'm going to play, just a little bit of a court. We're not going to see a court case from this court. I'm just going to play a little bit. There's this court that I never ever record from because the wood is so dark and it looks like they're all in hell and the judge is illuminated. And it was funny because when I went to get a clip of this court to show Cloud, um, the, the judge had a Spanish interpreter in there, so you're going to hear what it's like when this courtroom from hell has a Spanish interpreter in. Here we go.
Pueda ayudarlo a llenar ese formulario esta mañana. Tengo las tarifas de reinstalación de tarifas en este archivo que le mandé yo a él.
I'll take him down to my
Yo lo
office
llevaré a mi
and see if he
oficina
and I can
y
get
ver si
through
él y
this
yo
together
podemos
without a translator.
repasar esas cosas juntos sin el traductor.
And maybe we can get
Y
this done.
tal vez podamos hacer eso.
And I could be mistaken
Y
as
tal
far
vez
as the
esté equivocada
availability
por respecto a la
of the person
disponibilidad
who's
de
staffing
la
the
persona quien
access to
está
justice center.
trabajando el
Okay, enough.
Yes.
I can't take it anymore. I can't take it anymore. But see how dark it is in there? You're going in there, and some of them walk up. If you look right in front of the bench, there's that little shelf right there. Some of them stand in front of her there, like traffic cases and things like that. And it's, it's like she's so high, and everything is so dark. So, yeah, I don't get this courtroom that much just because the wood is too dark, which makes no sense. Anyway, I'm going to go on to the worst coworker ever. Let's just see what goes on with this woman.
Irate with Ms. Setliver, it was the other way around, that she got in her face and was irate with her. As to the recording, Ms. Dixon testified that she was saying that the post office was going to crack her skull regarding all of the fabricated statements she makes. Mr. Zirkle testified that 32 postmasters in 3 years have had problems with Ms. Setliver. There was an incident on January 3rd, 2024 relating to another employee and a 24 issue that she had with Ms. Setliver that Ms. Sentlever has a habit of trying to get people in trouble. That this happened with Darlene Atwood. He testified that Ms. Sentlever is not allowed to be a clerk. And it's unclear as to what he was getting at. I think there was some altercation between Ms. Atwood and Ms. Sentlever, and Ms. Sentlever is trying to get Darlene to touch her to throw her in jail. The court heard probably the most objective testimony was from Roger Daniels, the union representative of 11 years. He testified that there had been another grievance filed against Ms. Sentlever from another party, and that Ms. Sentlever was never able to supervise again at the post office because she was so abusive to the people she supervises. He testified that they have had to intervene quite a few times, had a lot of incidents with Ms. Sentlever because she makes everyone mad and crazy. And he testified that Ms. Sentlever asked him to take the grievance out of her file so she could supervise again. He also further testified on cross-examination that he's heard that Ms. Sentlever gets into screaming matches, telling people to touch her and then reporting it to the police, and that Ms. Sentlever has been designated as the aggressor on almost all of the occasions, and that she gets into numerous altercations. Now, the standard for a permanent protection order is that the court has to find by a preponderance of the evidence that Ms. Dixon here, the respondent, has committed acts constituting grounds for the issuance of a civil protection order, and unless restrained, will continue to commit such acts or acts designed to intimidate or retaliate against the protected party. What this court has heard is that it's clear that Ms. Sentlever and Ms. Dixon don't like each other very much. They don't get along. And while there's allegations, there's 3 allegations. One a long time ago in 2021, and then a couple of allegations in 2023, 3 allegations in 2023, and a recording. The court couldn't make much out of the recording, and even if it rose to the level of a threat of physical harm, which it didn't really sound like that's where it was going, the court does not find that unless restrained, Ms. Dixon will continue to commit such acts or acts designed to intimidate or retaliate against Ms. Sentlever. The court found the testimony of, I didn't find a whole lot of credibility in a lot of the testimony, quite frankly, except for the testimony of Mr. Daniels. Mr. Daniels' testimony provided the most insight to the court that Ms. Sentlever, you seem to be pretty difficult to get along with, and you get into numerous altercations, you provoke others. That is, whether that is accurate or not, it's the snapshot that this court got today. And so for those reasons, the court declines to issue a permanent protection order. The temporary protection order is vacated. Now, I know that this, Ms. Sentlever, this may be upsetting to you. However, a lot of this stuff, there are 3 incidences basically that occurred and not very recently. And it, in a nutshell, what the court could ascertain is that you and Ms. Dixon don't get along. And, that is bleeding into your professional relationship. Now, if after today's date, Ms. Dixon, if you do make threats to Ms. Centlever, and Ms. Centlever has documentation and files for another protection order, then I'm going to look at it carefully. But I don't find that second required element that unless restrained, Ms. Dixon will continue to commit such acts or acts designed to intimidate or retaliate against Ms. Centlever. And for those reasons, that's why I rendered the decision that I rendered today. Does anybody have any questions about my ruling?
I don't have a question, but I have one comment.
Absolutely.
Prior to coming to court, I called to find out what I needed to bring, and I was told to keep it as brief as possible. So had I known that I was allowed to give more evidence, I would have definitely brought more evidence to prove that what I'm saying is true, that I've definitely been threatened.
Well, nothing prevents you from hereafter, if threats occur after, and you have documentation, then you can file a protection order again if anything happens. But if I would caution you, don't just file things because you want to file things.
I'm not just doing that, ma'am.
Because then it's an abuse of the process.
Yeah, I'm not doing that.
Okay, good. Ms. Dixon, do you have any questions?
If I ignore you, don't talk to you, acknowledge you, how is it that I even?
You don't need to revisit that here. You don't need to have more conversations about that. So
Okay.
do you have any questions about the legal proceedings?
Well, yeah, I have been out of work for a week. What kind of,
There was a valid basis to issue that temporary protection order. And so, this is not a place where you're going to get damages here. I don't find that the action, the temporary protection order that was filed was frivolous. I just find that the second element doesn't meet the standard. There's no second element. All right. Anything further from either party? All right, I know that Mr. Zirkle, your case is set for 4 p.m. today, is that correct?
That's correct, ma'am.
Okay. Most of the hearing.
That's enough. She just talks about other courts later today. Anyway, so the first woman who spoke, she's the coworker that tries to get everybody to hit her. And I wasn't there and I didn't see the video, but the second woman who spoke, I think she did. I think this crazy woman messed around with the wrong person and found out. That's what I think. I don't know. Yes, Kelly, they work together at the post office, and the blonde lady apparently continually gets in fights with people, continually tries to get people to hit her so that she can get them arrested. And not once, not twice, continually does it. She used to supervise people, and then she lost that because she was too mean to everybody. And she can't be a clerk because I guess she can't be nice to the customers either. I don't know. But the judge was telling her, don't just file a lawsuit that's frivolous. She's definitely going to. She's definitely going to. Because this Miss Dixon, I don't think she's not going to take it. She just won't. You know what I mean? They're going to be back again. And I feel so bad for Miss Dixon. I just do. I'm so glad I don't work at the post office. Yeah, yes, Kelly. There's only so much someone can take. There really is. But it's funny, Kelly, because you talked about this courtroom and those stone walls. And you came in just like a minute late, and I just played another clip about the other courtroom. I never get cases from there because the wood is too dark. This stone looks like medieval. It looks like a torture chamber, but I'm fine with it. I'm fine with this. Just that other wood is too dark. I can't handle it. All right. This next one is interesting because the inmate is special. You'll see.
Vision would be needed, but what's the point of having a recovery court if you don't put people in recovery court who actually need it, Your Honor? He's indicated to me his desire to turn his life around, to move forward. I don't believe that community corrections is going to give him that same possibility as recovery court. That's pure and simple, Your Honor. He's standing in front of you on his first felony. There are consequences that are going to go beyond whatever you do in front of us or to him at this time, Your Honor. So the best thing that I'm asking for, the best thing that you can do is, help him going forward in a way that he can't do it on his own. He can't give himself recovery court. All he can do is go to recovery court and do his best. So based on that, Your Honor, I'm asking for, and what was contemplated in the pre-sentence investigation, I'm asking for that sentence to be converted to a recovery court sentence.
Thank you. Mr. Upchurch, what would you like me to know, sir?
Your Honor, I told you last time I was going to write you a letter. I actually happened to leave it on the pod on accident. I apologize about that. I couldn't go back to get it either when I remembered out loud.
No, just tell me what you want to tell me.
I wanted to tell you that, sir. I went to school, so I have an associate's degree in mathematics. I went to school. I actually went to school of mines for a year and a half for biomedical engineering. And I enjoyed it. I fortunately dropped out due to my drug abuse. I've ruined my relationships with my mom. I've ruined relationships with basically everybody I know because of my drug abuse. I actually got accepted into CU Denver for their physics program for theoretical physics and cosmological sciences and didn't go because of my drug abuse. I've had recurring issues, not just in my juvenile past, but issues even right now in my adult criminal history that are, completely related to my drug abuse. There's even charges that I've had in Douglas County that are just blatantly trying to have drugs inside of it, not even bring it, they're just trying to do drugs inside of the facility. Your Honor, I feel as though I was reading a book. I know this is kind of unrelated, but bear with me for a second. Okay, I was reading a book, right? It's called The Three Body Problem. And while I've been incarcerated this time, and it explained things like the Cultural Revolution in China, about how there were certain things that weren't allotted to people such as certain branches of education, right? And realizing that, I realized that not only has my drug abuse, right, have I been so hazed and so my perception of life has been so skewed by my drug abuse to where I don't realize like the things that matter, and that people have literally fought and died to have these rights to just learn things, right? I started to realize that maybe I should take advantage of these things, and I feel like the best way that I could start doing this is by getting accepted into recovery court, going back to school, getting a job, and getting my life on the right track. Your Honor, I feel like also that should be stated is rehabilitation before reincarceration. Before incarceration, I feel as though I should at least, be given the chance to at least, show what I got, to show what I can do in recovery court, rather than just being given a straight sentence to the halfway house or community correction. So, Your Honor, I'm sorry for earlier, but Your Honor.
It's all right.
Once again, I want to reiterate the fact my mom, she has breast cancer. She had breast cancer and she just had surgery. Either way, it's kind of like a chaotic situation for me. I feel as though, once again, I want to reiterate the fact that recovery court would be a very good opportunity for me to show not just the courts and the rest of the community, but specifically like my mom and the rest of my family, that I am going to take my recovery seriously. So that's all I have to say. Thank you.
All right, with the party's approach. Well, Mr. Upchurch, I got to tell you, this is your first felony conviction. You have a similar case in terms of factual basis pending in Douglas County. You have failed in probation in the past. and not done well. It seems to be the demon that you're dealing with that has created these issues for you is drug addiction. And I rarely have someone that comes in front of me who has the capacity and to have a bright future like you do. You're really smart. I mean, you're the first person that's come before me that spent a year and a half at the Colorado School of Mines, or who gets accepted into a program for physics. So you clearly have the intellect. And you mentioned math inside a courtroom, and every lawyer sort of perks up because there isn't a lawyer on the face of the earth that goes to law school because they can do math. It's because they can't do math. That's why they go to law school. So it's really impressive. And I'm going to give you the opportunity to put this, to get you on the right track. You have to understand, you're very articulate, and I get that. Somewhat manipulative, I get that too. When you rob somebody, you steal from them, the impact it has on that person is incalculable. It really is. And what you did was just shameful. Stealing is one of the most shameful things that one can do because it has such an impact on the victim. And they're always looking over their shoulder. So you have a lot to atone for. But I'm going to give you that opportunity in recovery court because I think that's the best place to give you that chance. And this is my long-winded way of saying, I hope you take advantage of it, because if you come back before me and you fail in recovery court, your chances of going to DOC, it's almost a virtual certainty, not community corrections, but Department of Corrections. You understand that, sir?
Yes, sir.
When's the next sentencing we have in recovery court? So I do hereby sentence you to, you've been accepted to recovery court.
On Tuesdays at 2:30, Judge.
And is Mr. Upchurch a Arapahoe County prisoner?
Yes.
Okay.
Yes, Your Honor.
All right. So I'm sentencing you to recovery court, bottom line. And let's get a date for you. What did you say?
For the other court date? Fourth, I have court.
At 2:30, 19 March at 2:30 in recovery court, okay? I have no idea what's gonna happen in your Douglas County case. I have no idea how that works out. I hope it doesn't derail this opportunity for you.
Well, they said, if I might, they said that if I get accepted here, then I should get accepted in recovery court.
Well, you would hope. I have no control over that.
Right.
But I hope you really take advantage this time
Sure.
because your trajectory isn't good.
Right.
And like I said, your promise in life is high.
Thank you, sir.
You got to decide which way you want to go.
Yes, sir.
All right. So you're going to be sentenced on March 19th at 2 p.m., right?
Yep.
Is that what I said?
Yes, Your Honor.
Madam Clerk, March 19th at 2 p.m.?
March 19th at 2:30.
2:30, okay. I wish you the best of luck, sir.
Thank you, sir.
All right.
So I'll let them.
So he's really, really, really different than the people we normally see in front of judges. I mean, I'm glad the judge pointed out that, yeah, you have all these good things going for you and you're working hard, but you're robbing people. No, he's going to community court, so they will definitely put restrictions on him. I mean, not community court, drug court, whatever. He's going to the, you know how Colorado has that other court system where they take people to try to help them, and they give them all kinds of resources. School, he won't need it because he already has his degree. If you need your ID, if you need food, if you need housing, but it's still court, and they still get sentenced there, and you know he could still go to jail and everything like that. It's not a walk in the park. It's just more help for some people. Colorado has a lot of resources, a lot more than the other states that I've seen. All right, this one is real quick, but it's interesting.
Before I forget, there's just a wrinkle that I wanted to address with Mr. Kantav and the parties, which is understanding the stipulated jail sentence in the event that he does in fact proceed with a plea of guilty. My assumption is that he was going to do that on May 1st. That's what you just told me?
Yes, Judge.
Okay. There is someone presently in the jail who is an alleged perpetrator of a crime against Mr. Kantav's daughter. And there have been some altercations, I believe, between that defendant and Mr. Kantav in the past. So I'm not asking anyone to do anything today other than think about that detail, because that individual is awaiting restoration at CMHIP, and there's no, I think, reasonable expectation that he would be admitted for restoration by May 1st. So I just wanted everyone to be cognizant of that wrinkle.
I really appreciate the court sharing that and reminding me of that, Judge. I'm sorry that I forgot that detail. Two things. First, I misspoke when I said May 1st. I meant May 6th. That's the May in-person docket.
Great.
Second, I will certainly follow up with Mr. Kantav and talk to him about the intricacies of that particular issue. And then it sounds like I can subsequently have a conversation with Mr. Stokes in the jail about any other options.
Okay, what other options? There are no other options. He's probably going to jail. I listened to the whole case, and it was boring. So this part wasn't, so I only left this part in. But yeah, he's going to jail. And there are no other options. They're going to see each other. I don't know how that's going to go. But remember, we saw that case yesterday with, what was her name? Anyway, the jail couldn't handle her. Her last charge, I think she had 6 cases in front of the judge yesterday, and the last one was violence in the jail. Like, she was violent to people in the jail. So that's, I don't know, you know, if I was locked in a jail with someone who had hurt my daughter, I don't know. I don't know how that would work out for them. But we do see a lot of judges where they fold to sob stories. But not all judges fold, guys. Not all judges fold.
Brian, are you in a position to address Mr. Hamby's case, or I think I'm not sure.
Yeah, unfortunately, I haven't been able to get the notes from Miss Trujillo. So I think she's just rejoined us, actually.
I think she might be on a call
Oh,
with
she's on a
somebody
call.
else, so I will.
Okay. If we could pass that.
I'll just watch.
I apologize.
Oh, there she is.
You could do Mr. Hamby's
Okay.
case. Thank you.
Okay. Thank you.
Thank you so much, Mr. Hio. The court calls People versus Jimmy Hamby, 23 CR 1705. Mr. Hio, did you have a chance to speak with him privately in a breakout session?
I did. Thank you.
And do you believe he understands his rights based on your conversation?
Yes, I do.
Okay, Mr. Hamby, do you have any questions about your rights, sir, that I can try to answer for you today?
No, ma'am.
Have you ever served in the United States military?
Yes.
Okay, the court just needs to advise you that there are some resources available to you, and I will ask that my staff email them over to you at the Adams County Jail. Mr. Hamby, it looks like there was a review of an affidavit in support of your warrantless arrest. There was a finding of probable cause by a different judicial officer. That judicial officer has set bond, but I am going to address it today. He's previously set bond in the amount of $250 cash only. The register as a sex offender. The court is required today to issue a mandatory protection order. In this case, it will order that you not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are alleged to have committed. What is the people's position in regards to bond?
Judge, we're requesting a cash or surety bond. I'm fine with the lower amount of $1,000 or $2, $1,000 or with pretrial release supervision. And I'm asking for that. The underlying offense in April of 2006, in which he was sentenced to probation, which was revoked, and he was sent to DOC. when he came to Colorado, specifically to Weld County, he did register, so he knew what he needed to do. Not only that, but he registered, after he failed to register, he was contacted, he was given those instructions, he was told what he needed to do, and yet he still didn't do that. So my concern is that there's a reason that that law exists, that we have people register, and I have concerns that the defendant may not return to court if they're in some sort of reporting with pretrial release that would be done.
Okay, thank you. Mr. Hill, do you wish to be heard?
Yes, Your Honor, thank you. We're asking for a personal recognizance bond for Mr. Hamby. He does not have any other cases pending. The last failure to appear was from 2017, and the majority of his criminal history here in Colorado is all traffic, and they are traffic misdemeanors. The underlying offense here, as noted, is from some time ago, and there have not been any other failure to registers that have been filed, pending, or even that he's pled to. Mr. Hamby does have a 16-year-old service animal or service dog, so it's necessary for him to be out of custody for to be able to be with him, as well as, of course, the benefits that the service animal does provide to him. He does live in Commerce City, where he has property out there. He's been there for the last 10 months, but previously was living in Greeley. This seems like some of the issues here revolved around him living in Greeley, and unfortunately his apartment complex here was closed down in order to build a golf course. So he's since moved to Commerce City, where he has his own plumbing company that he's had since April 2021. He also is a subcontractor for another plumbing company in Henderson, so does have significant ties to the community, owns his own business, so isn't going anywhere. He also has the ability to get himself to court should he have to appear in person. In addition to the connections that he has through his work, he does have family in the area. He has an uncle here in Weld County, and does need to support his uncle. He was the one that brought him out here from California, so his uncle does rely on him as well. Given the nature of the allegations here, without any other pending cases and the long time from the previous failure to appear, we'd be asking for a personal recognizance bond.
Okay, thank you. The court is going to modify set at $250. Conditions of that bond will be that Mr. Hamby comply with pretrial services, that he comply with the protection order, remain law abiding, and comply with any conditions of any other court-ordered community-based supervision. His next court date out of custody will be May 6th at 9 a.m. in Division 17. In custody, it will be March 6th at 1:30 in Division 17. Mr. Hio, do you believe that this is, I believe you indicated this was Mr. Hamby's only case, so can I assume that he'll be transported to Weld County, or should we prepare a video writ?
Your Honor, I believe he'll be transported up here if he's unable to post.
I'm not able to post, and my dog is about to die. I mean, I haven't had anything, ma'am. I haven't had anything in.
Okay, Mr. Hamby, I'm not negotiating with you. I just heard from the DA and from your attorney, and I've set bonds. So, Mr. Hio, I'm sorry, I couldn't hear you.
Ma'am, because
Meaning
you know
that
what?
he's going to be transported.
Just hold on a second,
Okay, I'm going to mute Mr. Hamby. Mr. Hio, you said you believe he's going to be transported?
Yes.
Okay, so next court date in custody then will be March 6th at 1:30 in Division 17. We'll make that notation. The court is in recess on this case.
I bet no one saw the dog. No one had the dog on their bingo card, did they? I'm begging you. I'm begging you. Okay. We're going to move on to the worst wedding ever.
Called an affidavit of relinquishment within 7 business days, or 7 days of today's date, excuse me, 7 days of today's date. So Mr. DeBassi, do you understand that protection order?
Yes, Your Honor.
All right, we'll go ahead and move on to hearing on bond. I've had an opportunity to review the people's position on bond. And just for your benefit, Mr. DeBassi, the people are requesting a secured bond in the amount of not less than $750. They're also requesting that any condition of bond include alcohol monitoring with the reports of any result or failure to attest to be filed with the court. Additionally, they're requesting that the protection order be a condition of bond. So Mr. DeBassi, do you have any position with regards to the people's request? We'll get into a little bit more in just a moment, but do you have any position with regards to the request for alcohol monitoring and the request for the amount of bond?
No, I understand.
Okay. I do want to ask you a few questions. Where do you currently live?
Blackhawk, Gilpin County, Colorado.
Okay. And were you a visitor here?
Yes, today's my birthday, and Megan and I were supposed to get married today, so that was the plan.
Okay, and are you currently employed?
Yes,
What do you do?
I paint vehicles for a living for car dealerships.
And how long have you had that position?
Oh, 3 or 4 years.
And do you currently have a driver's license?
No.
Okay, Mr. Bassi, do you want to tell me anything or anything related to why you think you're not a public safety risk?
No.
All right. And Mr. Mitchell, was there any additional information you wanted to provide me besides what's in the report that you provided to the court?
No, ma'am, only that Ms. Bruno, I believe, wishes to address the court.
Correct. I was going to call on her next. Ms. Bruno, good afternoon. Do you want to go ahead and provide me any information with regards to whether Mr. DeBassi is a public safety risk or harm or potential harm to you?
Hey, yes, that Sam not a public safety risk. He made a mistake, and it was honestly fueled by alcohol, which he's struggled with. I feel that this $150 bond, I really want him to get out. I'm at the Montrose County Courthouse right now. This is where I thought the bond hearing was going to be. And we both work. Even though we work hard, we live paycheck to paycheck, and not to be able to work or with a high bond would be difficult for both of us. Some research for intensive outpatient programs for him, address his alcohol use and the underlying issues which drive them, because he can go long periods of time with no alcohol. You feel like he's white knuckling through it, and there are underlying issues from his past that I feel like he could address and live without the emotional burdens that he carries every day. And he just made a mistake. He drank too much, and as an alcoholic does, because I'm sober, I know how it goes. Once one starts, it's hard to stop. And with a protection order that he can't drink, and getting him into treatment, which I contacted 3 different places. As soon as he calls them and does the assessment, they get him in under 72 hours to start. So I wanted to talk to him about that. To be able to drive today, I have to be at work as well. And that he contributes to society. He has a full-time job. He has an apartment. He has pets. He's close to his family. And he just made a mistake.
So the judge asks him, his freedom is on the line. He messed up. He's the one that's sitting in jail. Is there anything else you want to say? No, Judge. All right, well, let me talk to your fiance. She goes on and she says every single thing that he should have said. You know, I have ties to the community, I work, blah, 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 blah. And she went on and on. She did great. And he's just sitting there like, nah, I'm good.
Ms. Bruno, thank you for your input. I'm prepared to go ahead and issue my order. I have no concerns about Mr. DeBassi's flight risk. There's no failures to appear in his history, despite the fact that he does live some time away or a little bit of a distance away. He does live within the state of Colorado, and he does have a driver's license and so forth. That said, I have pretty significant concerns about the underlying allegations in this case, as well as the fact that he's recently convicted on February 26th of 2024 and sentenced 2 years of probation and 23 CR 36. Additionally, he has some previous DWAI convictions indicating that he has a serious alcohol problem, which are the underlying issues in this case as well. For statute, when someone is not, or when somebody is on probation or has an open case, and the DA objects to a PR bond, I cannot issue a PR bond. So for those reasons, Ms. Bruno, I'm not going to be issuing a PR bond. And based on my concerns for the underlying allegations in this case, I am going to be issuing a cash-only bond in the amount of $750 cash only as requested by the DA. I'm not going to be doing a cash or surety bond. That's a cash-only bond. And I will hold on just a moment, Ms. Bruno. I am going to require as a condition of bond that Mr. DeBassi undergo alcohol monitoring with reports of those results, as well as any failures to test to be submitted to the court. I'll also make the protection order a condition of bond. And Mr. Mitchell, are you requesting anything further?
No, thank you.
We'll need to go ahead and get a new court date, but first, Mr. DeBassi, do you want the assistance of the public defender on your case, or do you want private counsel?
Just use your fiance. No, use your fiance. Do go ahead.
We'll go ahead and set your case over. Do you think you'll be able to bond out?
I have no idea.
Okay.
I don't have that cash on me. I mean, I'd need somebody to bring it, you know?
Let's do this. Go ahead, Ms. Bruno.
I'm at the courthouse in Montrose, and am I able to pay it here, or do I have to come to your Ray to pay it?
You pay it at the Montrose County Jail.
Okay. Yes, he'll be bonding out.
I'll go ahead and set this case over on March 14th at 10 a.m. and I'll set that for a compliance hearing. Mr. DeBassi, what that means is you'll need to submit that firearms affidavit within 7 days of today's date, and that next hearing is to make sure that you've complied with it.
Sure. Sorry, I do have a probation meeting. Like, I'm setting up probation for my last case you were talking about on March 14th.
Okay.
It's either the 13th or the 14th. Is there a way I would be able to do it like remote, like we're doing it now?
Mr. Mitchell, do you have any position with regards to remote?
I don't object for the next hearing.
Okay. In that case, I don't have an issue with that either, Mr. DeBassi. Typically, when there's just plea hearings being set, defendants are allowed to appear via WebEx by and large, unless there's a number of other circumstances at play. Since this is a compliance hearing, typically I would require a defendant to be here in person to submit that if they haven't submitted it and don't have an attorney. But I'll allow you to appear via WebEx as long as you've submitted that affidavit prior, within 7 days of today's date, okay? There's an affidavit there in front of you that the deputy will have provided you, and you can submit that to the court or back to the jail, and they'll provide it to the court, okay?
Okay.
Okay, so we'll have you come back on March 14th at 10 a.m. and I'll authorize your appearance via WebEx as long as you've completed that affidavit and submitted to the court.
Perfect. Thank you, Your Honor.
Okay, anything further in this case, Mr. Mitchell?
No, thank you.
Anything further, Mr. DeBassi? Any questions?
No, thank you.
All right, thank you. We'll see you on the 14th. Have a good day.
Thank you, Your Honor.
Enjoy your wedding day. Enjoy your wedding day in jail. Maybe he will get married in jail. You never know. You never know. Yeah, I can have 2 weddings. One in and one out. I mean, people have, work husbands and work wives. And then they go home to their real wives. So he can have a prison wife. And then when he goes out, he can have a real wife. So this next one, there's a case. And the judge gets a little cranky. Just a little bit. But then after the case is over, then he gets really cranky, and it's lovely.
18 CR 2523. Mr. Glasgow appears in person. He appears in custody. He's joined by his Deputy State Public Defender, Mr. Duran. Ms. Clark appears on behalf of the prosecution. I know that Allison Gordon, his 35C counsel, wanted to be heard also today on bond. Is Ms. Gordon joining us? Looks like she is not.
I do not see her. I believe Mr. Glasgow's father was on WebEx, though.
Yep, I saw that. And prosecution, anything you'd like to say with regard to bond setting?
Yes, Judge. First and foremost, I want to address the complaint to revoke probation. I want to note that though there are several allegations, I want to note that for the most part throughout each of these allegations, there are several instances where it shows Mr. Glasgow's compliance and contact and communication with probation even throughout these violations. That there were a couple missed UAs and missed appointments, but for the most part throughout this time period, he has made his appointments and made his UAs. Obviously, we're not here to dispute those today. That would be for a hearing on revocation of probation. I also want to point out that there has never been throughout the pendency of this case any failures to appear. So when the court's considering factors like willingness and probability of Mr. Glasgow showing up in court, I don't think that that should be a concern for the court. This case obviously went to trial. Then there was a revocation revocation proceedings. In both instances, Mr. Glasgow was on bond and had no trouble during bond either complying with conditions of bond or complying with conditions of probation while on bond for the probation revocation matter. I can also tell the court that if Mr. Glasgow were to be given a bond, it's his every intention to continue to comply and to continue to try to get back in compliance with probation. The most important factor of which is to re-enroll in the treatment. He understands, and I understand that this may not guarantee any likely outcome in this case, but that with the possibility of the court reinstating probation or sentencing to community corrections, that treatment would still be necessary and
Or
appropriate.
prison. It's a lifetime supervision.
Right.
case.
I'm not saying that prison isn't an option. I'm saying that because those two are options and those two would come with treatment, that if he were to be considered for those, it would be important for him to get started on that treatment and get re-enrolled as soon as possible. I will say that Mr. Glasgow's father is online. I do not know if he wishes to say anything on behalf. I will ask the court to inquire that of him in a little bit. But I do want to know that his family support has been constant from the beginning.
Absolutely. I remember his family filling up the courtrooms. I know he has a lot of family support.
Yes, Judge. They're all here in the northern Colorado area. If he were to be released, he does have stable living. He would live with his grandmother. who has served as his caregiver throughout the proceedings of this. And I want to remind the court why we asked to set this for a bond hearing today, or earlier if the court had it, it just did not. Today was supposed to be Mr. Glasgow's first day of college at IBMC. He was starting a program for barbering. He had spent several months saving and trying to be able to afford a semester's worth of education. And it's his every intent that he wants to first and foremost get back in compliance with treatment, get back in compliance with probation, but also continue to try to build that stability and support while he's out in the community, and try to continue to set his future life up better for himself. I think that the court should consider imposing a bond in this case, given all those factors, given the fact that the court should not have concerns about him reappearing to court dates. Obviously, he understands the possible penalties that he is facing. He has faced those from the beginning in both a revocation matter as well as the original trial pendency, and has still maintained his responsibility of coming to court and handling this case appropriately. Previously, I believe he was out on a $30,000 bond in the original case, and then a $50,000 bond in the revocation proceedings. We would be asking the court to set something similar today, preferably in the lower range of that, given that he has consistently shown a willingness to come to court. And that would be our request at this time.
Thank you. Mr. Patrick Glasgow, even though your son's an adult, I know you've been very involved in his cases. And so if you would like to say something on behalf of your son.
Thank you, Your Honor. I would like to, Judge Kapkow. I just want you to trust my words right now. Travis will not go anywhere. We were going to 100% deal with this. Also, that it's not black and white like it looks like. I can promise you that. I feel strongly to 1,000 degrees, and I feel personally, Your Honor, I mean, anytime that we did have a situation and we are dealing with someone that has a severe handicap, and that's hard to understand at times, but it's a reality. And I would ask that you would do a pure bond for
when you
Travis
talk
in
about
this
a handicap,
situation.
when you refer to the handicap, you're referring to that horrific accident that he was involved in that I handled a 2-week civil jury trial back in 2016.
Which you know very well because you did do that.
Yes.
It was a severe traumatic brain injury. He has a plate in his head. And I would ask in this situation that you would give him a PR bond. And the reason why is that Travis has worked hard. He went through a whole disability thing to get this on his own for this college deal. I'm very proud of him for that. There are some things here with some interpolitical things that I know about. You do not know about. I'm not going to talk about it, but created a very bad situation that was unfair. And there's been details that have been recorded because of the family support. I think you can see that his aunts are on here, his mother, his cousins. We care deeply for him. We're not just saying it. We try to do it, and we also are very accountable for him. And I just hope that you understand from my words what I'm saying. And that would be it, Your Honor.
Thank you.
So I always hear the defender and I always hear the families and I always pick a side at that point. And it's like, oh, this guy's going to start college. He has so much, it's not fair. It wasn't his fault, blah, blah, blah. And then here we go. The judge speaks and the prosecutor speaks. And then it's like, man, damn.
Ms. Clark, anything you'd like to say on behalf of the prosecution?
Yes, Your Honor. First of all, the people are not without knowledge. I understand that Mr. Duran is relatively new to this case. This court is not, and I am not. I prosecuted the underlying case. I've been here every court appearance since. We are not talking about missing a couple of appointments and otherwise showing up. We are talking about who came to court a year ago on his last revocation, and this court looked him in the face and said, you understand this is your last chance. You're facing indeterminate prison, and if you screw up again, you're going to prison. And so the things that have previously brought him to court consistently, and the court can see that many of those things are actually people who have logged on and who have been very supporting for him, they can't do this for him. That is absolutely clear through his track record and through their efforts. They have tried, they have been here, and he has insisted. If this was technicals, if this was a traffic ticket, I would not be asking the court to hold him without bond pending a hearing, but it is not. We are talking about a person who is alleged to have made recordings of group therapy involving other people's very personal, very confidential information, potentially rising to the level of criminal conduct in the one setting that is supposed to keep this community safe and to keep him from reoffending. He's not welcome back in treatment, and this particular treatment provider was selected specifically because she was so qualified to work with him in light of his traumatic brain injury. And so while I'm sympathetic to the fact of his injury, at some point, it's not a crutch. And at some point, you have to do what this court essentially promised last time. I'm asking that it be held without bond, and if they choose to ask that the case be set for hearing, I'm asking the court do that.
Thank you. So the court has considered the statements made by the lawyers, the statement made by Mr. Glasgow's father.
But wait, there's more.
16-4-10. Remind everybody, I think it's been mentioned, one of the things I have to consider is the likely sentence. If Mr. Glasgow has his probation revoked again, he is potentially looking at a indeterminate sentence in the Department of Corrections. I stated that during the initial sentencing hearing. I stated that during the resentencing hearing. Mr. Glasgow now has been discharged from offense-specific treatment twice, and I agree with the prosecutor that this latest treatment provider was hand-picked based on Mr. Glasgow's mental health and medical situation. I very intentionally set no bond in this case based on the allegation in this case. Quite frankly, I can care less about his careless driving charge as in paragraph A. That's not the reason he's being held without bond, but it's all these other alleged flagrant violations of sex offender intensive supervised probation. And for those reasons, while I appreciate the fact that you're trying to get an education, that when I weigh that compared to the concerns I have in the community, that I'm not going to change my mind. I believe that a no bond hold is appropriate. Don't have concerns about you showing up to court. I have concerns what you're doing in the community, and concerns about community safety. And so the court is denying the request to set bond. I am exercising my discretion, as I stated last time, pursuant to People v. Johnson, 2017, COA 97, to have you held without the ability to post bond. Did you want to set the matter for a revocation hearing? I know that we're currently scheduled also for a filing of a petition under Rule 35C. And so what would you like to do, Mr. Duran?
Judge, if the court's willing to, it would be our request to set this for a disposition only at this time and reserve his right to have a hearing on revocation of probation. The reason being is partially because of that 35C. It doesn't really have to do with the 35C claim itself. Ms. Gordon and I have been in contact, and we're working on getting releases for each other and sharing information that the other has, so that we are, as well as myself, trying to get the narratives and file from the probation. And so I would just like to make sure before we set for that I have all of that information.
Looks like the supplemental petition for the 35C is due on May 13th. Did you want to set something soon afterwards?
That would be acceptable to us.
You okay with that, Ms. Clark? I'm sorry, Ms. Clark?
I think that's fine, Judge. I think if we're setting that far out, then, I mean, the people might be asking to set for a hearing at that appearance if we haven't.
Okay, and I do see that Mr. Glasgow has previously waived the 14 days to have a hearing on February 22nd. He's not requesting the setting of a hearing today, soon after May 13th. How's May 14th, 9:30?
That's fine for the people.
Yes, Judge.
Okay, we'll see you in person on that next court date. Thank you.
Judge. Thank you, Mr.
People versus Gabriel Mori.
All right, Cloud. Yes, I started without you, but I thought of you. You were with us in our first stream. In our first video, because that was all about the wood paneling. So I showed that at the beginning. So now the judge just and Sally Port, thank you so much for the gifted memberships. That was so nice. So the judge just got a little annoyed there. This guy's a sex offender and not the victim. I know the father is saying this guy's a victim. It's not what you think it is. It's political. No, he's a sex offender. And he had a lot of chances. And he keeps messing up his chances. So now the judge is already in a bad mood. So here we go. We're going to the next case.
18 CR 1485, 20 CR 416. Mr. Mauricio is joining us on summons in person. He's joined by his lawyer, Ms. Jones. Mr. Rudolph appears on behalf of the prosecution. These matters come on for a dispositional hearing, and if the parties do not have one, we're scheduled for a revocation hearing this afternoon at 1:30. Do the parties have a disposition?
We do, Judge. I'm just awaiting paperwork. If the prosecutor believes that he can get me the paperwork, I think that we could proceed to disposition this afternoon at 1:30. If not, I'd request a date later this week.
No, we're having a revocation hearing at 1:30. We're set for disposition now.
I don't have paperwork now.
There's a bit of confusion. These were my cases, and it looks like actually Ms. Jones with Mr. McEwig reached an agreement that I was alerted to this morning.
So can you do the paperwork now? It's a revocation.
It contemplates a global that includes some county matters. I believe.
Did we ever get notice of that? This is not the way to handle a docket. Time is valuable in a docket. And so when we set for a disposition, that's what we're set for. When we're set for a revocation, that's what we're set for. If the parties wants us to handle county court cases, I've always volunteered to do them. Give me some notice. You haven't given me any notice. If you have paperwork on these two cases, I'll be glad to handle them now.
I don't have paperwork with me right now.
I'm going to take a break for about 5 minutes. Let me know when you're ready.
Lawyers get no mercy from judges. None. Period. That's it. He said, just get it done now, right now. No, we're not doing what you want to do. There are rules that you have to follow in court. Now, pro se, they don't have to follow the rules, and the inmates, they don't have to follow the rules. But if you're a lawyer, that's it. You have to follow the rules. Yeah, be prepared. Jim's always prepared. Always. All right, now we're going to go to... So, I go through a lot of court cases every day, and so do you guys. And there's really just two main cases repeated over and over and over and over again. It's either domestic violence, no contact, or DUI. Domestic violence, no contact, or DUI. But no contact, people just don't understand what that means. They just don't.
I mean that those injuries were not incurred as a result of self-defense.
Understood. Thank you very much, counsel. This was very thorough, and I will now hear from the district attorney.
Yes, Judge. Notably, the law enforcement notes how many times they have to deal with issues between Mr. Freeman and Ms. McNeese. The defendant, Mr. Freeman, recently filed a letter asking for the protection orders to be modified. He's a victim in BACA 23M21 and 23M39. Mr. Freeman used funds from the Victims' Compensation Fund in these cases to relocate to another area and then subsequently moved right back in with Ms. McNeese. And so I think part of this problem is of his own creation. 1033 Santa Fe, that's listed as the defendant's residence, is the long-known address of Rick McNeese, who is Tika McNeese's father. So if the defendant is living there with with Ms. McNeese's father, that's sure to create some issues. The people thought that the defendant had 2 felony convictions, and we may be wrong about that. We see a 14 CR 838 for flight or escape. And it looks like there's also a 10 CR 2879 for aiding a prisoner escape, but it's the 2010 one is not so clear if that's a conviction or was pled to a misdemeanor. There were multiple failures to appear, 8, I believe, from July of 2020 through October of 2022 on cases in other areas. Morgan County, I think, had quite a few of those. But other than that, Judge, I think the court will remember Ms. McNeese and her behavior in court the last time we were here. It's clear that the only thing that's keeping these 2 apart is one of them being in custody. And if the defendant's released on a PR bond, even if a condition of the protection order is compliance with the protection order is a condition, we're sure to see these folks back here in front of Your Honor again soon.
Judge, may I respond to that?
Yes, go ahead. Thank you, counsel.
Just 2 things, Judge. You can look at the minute order from February 18, 2024, and Judge Johnson specifically made a finding that 1033 Santa Fe, it's in Springfield, Colorado, is the defendant's address. And so I can appreciate Ms. Esch's statements to the court, but simply because it might have been Mr. McNeese's property at one point in time, it doesn't make it so at this point in contradiction to a
Yes,
court
it
order.
does.
Second of all, Judge, the prosecution argues what's basically preventative detention. She argues that a victim who called law enforcement because he was being victimized in this case should remain in custody so that the 2 don't have contact. That's an invalid argument under any provision, but certainly under 16-4-103, which does not articulate a goal of bond to be preventative detention. And so again, Judge, if Mr. McNeese were to plead guilty today to these charges, I'm not saying he would, but if he were to plead guilty today to these charges, he has been in custody since February 17th, and it's unlikely this court would impose more than, let's see, that's, my math is bad, but since it was a leap year 14, it's unlikely the court would impose more than 18 days in jail regardless. So to argue that he should remain in custody as a step of preventative detention really just misses the point of the bail statute. And so I would ask the court to take all those factors into account and grant him a personal recognizance bond. Thank you.
Thank you, counsel. You bring up an interesting point about the preventative detention, but one of the considerations that I have to take into account is any facts indicating the possibility of violations of the law if the person is released without bond conditions. So I think this is where Counsel Ash was going to. There has been what I think needs to be mentioned, 22M 814 violation of protection order, 22M 918 violation of protection order, 22M 271 as well as 22M 402, all violation of protection order cases. So how do I know this defendant doesn't go out and cause more damage or injure someone? I understand the argument about this, that he's been in jail for longer than maybe he would have ultimately got if convicted, and at this point he's not even convicted. I understand that argument. But what happens if he goes out and hurts somebody? How do I know he doesn't?
Judge, I can appreciate the court's comments. Those are cases that involve a different alleged victim.
That's his argument. His argument is no, 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 no. Those other domestic violent cases were against a different woman, so they don't count.
In a different county, that being Weld, Larimer, and Morgan. And all I can tell you is that it seems very unfair that because Ms. McNeese has greater ties to this community and has money, that the person who initiated this contact and initiated this incident, and the person who the person who really is the defendant in this case is able to be out of custody because her parents have money, and my client who doesn't have money and doesn't have family directly in the area, and because he's poor, and again, the one who did call the police stays in custody. All of those seem very fundamentally unfair. With respect directly to your question, you can certainly lecture my client. You can certainly advise him, that will make a difference on your acceptance of any agreement or of anything in the future, including a motion to revoke the bond. But I can't directly answer that. I understand that his record stands for itself.
Thank you, counsel. I appreciate that. All right. So, Mr. Freeman, as the district attorney has stated, and I agree with her, the reason you're here sitting at this table is your own doing. Your own doing. You knew you shouldn't be having contact with her. At the same time, I do appreciate you having a job at a big R and trying to be a manager there. And that you are financially in a difficult situation. I do appreciate that, the low CPAT score. So because this is your first case with me with this protected party, I am going to grant the PR bond, but please understand, if I see you again, I will not be this lenient. So I am granting the PR bond, especially taking into consideration how long you have spent in jail. But please know that you have caused, your relationship with Ms. McNee has caused a lot of work for the local enforcement, for the law enforcement, for the district attorney, and for the public defenders as well. And if you're in this situation again, I hope you're not, I will not be this lenient. So I'm granting the motion for PR bond. Mr. Freeman, please behave yourself, and everyone have a wonderful day. This hearing is adjourned.
Judge, could the court condition the PR bond on compliance with the protection order that's no contact?
Counsel, thank you. The no contact remains in effect. Mr. Freeman, this is all in your hands. How this goes and how this plays out in the future, all in your hands. And all you have to do is not have any contact whatsoever with the protected parties. That understood?
Yes, that's absolutely understood.
Okay, very well. Well, best of luck
No,
to
it's
you,
not.
and this hearing is adjourned.
I think she had to.
You're welcome.
Thank you.
I don't know what was going on at the end there with them, with the lawyer and him, but I think she had to. I mean, his lawyer was right. He's been in jail for more days than what he would have got if he was convicted. So, they're gonna let him out, but I don't know what she can do next time. There will be a next time, most definitely. All right. This next one is backwards. 3 things happen, but in the wrong order, and it just, I was going through this. I had to rewatch it like twice because I was doing other things while I was trying to figure out what was going on here. But you'll see. Maybe, or I'm just crazy and it's not backwards to anybody but me. That's possible.
Ya sería muy tarde para yo llamar, como cuando él intentó matarme en mi propia casa, delante de mis hijos, pues yo ya no pude hacer nada.
So yeah, that's I have that. To me, that's very clear. Another thing that it's very clear to me is that if he tries to do something against me, then it would be too late. Just like when he tried to kill me in my home in front of my children, it was too late then.
Gracias.
And we all understand that. She's the victim. She's his girlfriend or whatever. She's the victim. And, you know, they're telling her, oh, don't worry, there's a protection order in place. And they're like, well, she's like, that piece of paper doesn't do anything. It's too late for me to call the police. It'll be too late. And there's nothing the judge can do. But, or hold on, we're just going to keep watching.
Gracias por permitirme hablar. Igual le repito, si esto se va a ir a juicio, yo estoy preparada para el juicio. Y estoy preparada para que me escuche usted y se dé cuenta de todo el daño psicológico y emocional que él ha causado, teniendo que pagar psicólogo para mí y para mis hijos para poder salir adelante después de este suceso.
And thank you so much for letting me talk. And also, I just wanted to let you know that I'm ready to go to trial. Prepared for you to hear all the psychological and emotional damage that this has created, all the money that I have been paying to get psychological assistance for me and for my children after this incident.
Thank you, Ms. Escobedo.
Thank you.
Mr. Brown, any comments on behalf of Mr. Candia Romero?
Your Honor, from what I can gather, it is a fully stipulated agreement. And so I really have no other comments to make. I just ask the court to impose the agreement as it has been stipulated to, and then allow us 14 days to file a brief. And I don't know how long Mr. Carson may need to respond. And I could have that in sooner if I wasn't in trial right now, but I would ask for 14 just because I am in trial.
How long would you need to respond, Mr. Carson?
If we're doing 14 days from today, Your Honor, the 18th, I think I could respond within 7 days after that.
All right, thank you. Sir. Mr. Candia Romero, you have a right to make a statement before sentence is imposed if there is anything else that you want to say.
No, sir, that would be all.
At this time, the court is going to enter a conviction against you on the charge of third-degree assault, a crime of domestic violence. I'm in order that you be placed on probation, supervised by the probation department for a period of 2 years.
Okay, so I get mad when I get to this part, probation. He gets probation, so he's going out. He's, you know, going out on the street, and she was right. You know, there's nothing stopping him from going to her right now. But wait, hold on.
Immediately after court today, you are required to go downstairs and meet with the probation department. Do you know where that is? Do you have a minute to show? Okay, Mr. Brown will show you where that is. You will be subject to what we call standard conditions of probation. These are things that you would probably guess would be conditions of probation, like you cannot break the law. You must show up at probation when you are told to do so. The court is going to impose 2 specific conditions of probation. Three, excuse me. One, I'm going to order you to serve 60 days in the Routt County Jail.
Oh, okay. Wait. What? Okay, wait. So he was on probation. After court, he's supposed to go down to probation and, schedule an appointment with them or talk to them. But now he's going to jail for 60 days? That is what the judge just said, right?
It looks like you posted a bond the day after you were arrested. If that is right, you are entitled to 2 days credit against that sentence. So I'll give you credit for 2 days that you have served. I will require you to undergo a domestic violence evaluation and successfully participate in and complete any recommended treatment. I'm going to order that the protection order remain in place during the period of probation. I will order that you pay the minimum mandatory financial assessments that I'm required by statute to impose. You must meet with our collections investigator. Is she here today? She is. Her name is Amber. She is here today in the clerk's office. If you need to set up a payment plan, she will meet with you and work that out with you. So after court today, you must go to the probation department and you must meet with our collections investigator regarding the fines and costs. Mr. Carson, are the people in a better position today to make a restitution request?
No, Your Honor, unfortunately, and it sounds like there may be some supplemental to that. I would request to the same date that the response to the motion to withdraw the plea is due, if we could have until then to finalize the restitution numbers.
Objection.
All right. Well, the Supreme Court last Monday frowned on that process, but the court will grant the request. So, Mr. Candia Romero, I'm going to order that you surrender to the Routt County Jail to serve that sentence. On April 12th, that's a Friday. That will allow time for your lawyer to file a motion, for the prosecutor to respond, and for me to enter a finding and an order. If I determine that a trial is appropriate and your plea should be withdrawn, then you will not have to comply with probation until after that trial is over.
Okay. Now we're talking about a trial. So first, he must have pled because he was sentenced. He was found guilty. I heard him say that he was found guilty. I heard it. So the verdict is in. And I heard him say, you're on probation. Then I heard the judge say, and then you have to spend 60 days in jail. And now the judge is saying, if there's going to be a trial, then this is going to happen. See what I mean? This is completely backwards.
Do you have any questions?
I have a lot of questions. A lot, Judge.
Anything else from the people today?
No, Your Honor, thank you.
Anything else, Mr. Brown?
No, Judge, thank you.
So meet with probation, meet with our collections investigator, stay in touch with Mr. Brown.
Okay.
All right, and then you're free to go otherwise.
Thank you very much.
Thank you, Ms. Johnson. Sorry about
Your
that
Honor.
delay.
No worries, it happens. Thank you.
Thank you.
Thank you, Your Honor.
Okay. What time are you back?
1:15.
So sorry.
No, that's okay.
We
She's got all the heavy.
do see those cases. We do see it when they take a plea. They'll say, I'm going to give you the plea. If you don't like it, then you can withdraw the plea and we'll go back and it'll be like this never happened. That was the first time I've ever seen it happen like that, though. So I'm watching this and I had to keep rewinding it. Like, what? Wait, did I miss something? What did he say? So that was completely backwards and broke my brain a bit, but we got through it. All right. I've been showing you guys a lot of lenient judges today, but don't worry, I'm not going to leave you like that. I wouldn't do that to you.
Like normal and drop down after a year and a half. That was pretty.
The audio on this is not the greatest. I did boost it for this. I can't boost it anymore because then it gets all crackly and you can't hear anything anyway. But you do hear it.
And now I'm actually into around 100. So I went from drinking liters of vodka to just beer to right now I'm actually trying to let it go completely. Like on the Vivitrol shot, which is something that if someone doesn't want to stop drinking, they wouldn't take it because it's painful. It's painful when you drink on it. It's pretty much an abuse. It's pretty much self-torture.
Just in case you can't hear him, he has alcohol-related issues, and he actually took that shot. I don't remember what it's called. Oh, sugar. It's on the tip of my tongue. And Suboxone? I think that's what it's called, Suboxone. I could be wrong, though. But my friend was telling me about the Suboxone. You get this shot, and then if you drink alcohol, you just get violently ill. I mean, it's just, you just get ill. But people who take Suboxone, like him, they still drink. I mean, they do still drink. But he's saying that, he is dead serious about not drinking anymore. He is dead serious. He even got the Suboxone shot. Don't worry, Judge, I'm okay.
It's an injection, so not a pill that you can just go back up. It's in your system. I've been working on whatever I can. I can't do my plumbing, so I'm not making as much money as I can. Kind of hard to afford the UAs, and then I was told not to do community service once I was done with all my classes. And sometimes I'm just a little behind on my classes because I wasn't able to afford to continue on. So, and the drinking that I'm doing, it's out of the, I guess probation can't give me vouchers for that. So I have to pay out of my pocket on every single one of those classes. But I'm still continuing, and I'm pretty close to the end on it. I'm almost finished up with that. Other than that, when you asked me that I drink, I told the truth, and I said yes. So I was in pain. I screwed up, and I drank and tried to take a shortcut to kill the pain. But I'm a very honest person, and Miss Favory, when she asks me if I drink, I tell her that yeah, I have to slip up. All I can say is that I'm trying, and not just doing it just for the courts or anything. I was doing this already before court started or anything like that. And I was doing this just to better for myself and for my family. That's pretty much all that is.
Mr. Tejeda, I think I remember telling you, maybe it's the last court date or the one before, that actions speak louder than words. When I put you on that scram for the second time, the concept was if he can stay clean for that period of time that I put him on scram again, I'll give him another chance on scram. It was going to be 120 days with a year of jail suspended, but I was going to do that. And then he tested positive for alcohol again. Mr. Tejeda, I have basically two things I have to consider when I consider someone's punishment. First, I have to consider what's best for the individual. What will serve that individual the best as far as do they need jail? Do they need treatment? Do they need this? Do they need that? That's the first thing. The second thing is the needs of the community. How do I protect the community? And in this case, I look at it, and probation has tried everything. I have never, in my experience, and I've been doing this for 33 years, seen this much effort go to one individual on a misdemeanor case. Okay, so they've tried everything. I have tried everything. I've given you chance after chance after chance. And every time I give you a chance, I'm rewarded with a positive test. And while I think you're in a dark place right now, and while I think that you're trying to work your way out of it, I have that other thing to consider. And the other thing is the safety of the community. And quite frankly, sir, if you can't stop drinking in a period of 4 years and you continue to test positive for alcohol, I have to do something to protect the community because you are a danger to the community. I have been to the scenes of hundreds of vehicular homicides. And I have never, ever prosecuted somebody who's committed a vehicular homicide who I thought was evil or a bad person. And quite frankly, most of them are just like you. They're just people who have alcohol problems, but they get out and drive. They go do things. You were, in this case, you were on your third DUI. You're not doing that well on probation, and then you pick up a new offense, and it involves alcohol. Now, it's an allegation. I don't know anything about the facts besides the fact that you were under the influence. And that's concerning to me. And this is your third, not your first, not your second. Another one is a felony. I can't put you on JHA because you can't do it. You haven't shown me at all. Ms. Wood is right. There's nothing much we can do. It's too late. We've tried and we've tried and we've tried for 4 years or 3 years, and it's just nothing. Court will find that the defendant has been terminated and revoked, and as such, the court will sentence the defendant to 1 year of jail.
Your Honor, could I ask that Mr. Day to be given 2 days in order to
No.
get it?
No. We've reset this multiple times. He's going to jail.
Yeah.
Never take that out.
There you go, Jim. That was for you. To jail he goes. So, I don't go on YouTube anymore to get court cases, but I used to, and the Colorado judges that are on YouTube, they're very wishy-washy. Very, 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 very wishy-washy. But since I started looking at the other judges in Colorado, they're not as harsh as Indiana, but they're not wishy-washy at all, and they do send people to jail. They just do. Michigan, you never know. Sometimes they do, sometimes they don't. Washington, never. And if someone's in jail, they find anything that they can find to release them. I've looked at a lot of Washington cases, not just YouTube cases, and all the judges are like that. If there's the slightest argument of why that person should not be in jail, like their dog is sick, then yeah, they're going to get out. They're out of jail right away. But In Colorado, you get both. You get both, but there are some hard judges in Colorado. We are going to find the good ones. We're going to have our own little playlist of judges. We will. We will. It'll just take time. Well, thank you so much for coming out tonight. I really appreciate it. Sally, thank you so much for all the memberships. Yeah, a bee stung me. I need to get out of jail. My dog stepped on a bee. Anyway, thank you for coming out, guys. I appreciate it. Court's open soon, so I need to get off here and get ready. I will talk to you guys again soon. I hope you guys have a great day. Bye.